This is Series 1 in a video series that I am doing to educate and inform on Julie's bill. And what that is taking the federal legislation that was passed this year in the Violence Against Women Act and adopting the Keeping Children Safe from Family Violence section of that federal legislation and passing it here in Wisconsin. The federal Keeping Children Safe from Family Violence is also known as Caden's Law, and I had the pleasure of meeting Caden's mom this year and just want to take a moment to acknowledge her journey, her bravery, acknowledge the grief and the loss of Caden and the sacrifice that her mother has dedicated to the legacy of her daughter in advocating and working to see children protected in custody proceedings. And this video is discussing what is the purposes that were identified in that federal legislation for enacting the Keeping Children Safe from Family Violence Act and what we're looking to pass here in Wisconsin in Julie's bill. And in this first purpose that's identified in the federal legislation, it states, increase the priority given to child safety in state court, divorce, separation, visitation, paternity, child support, civil protection order, or family custody order in any action affecting the custody and care of children in family court. And why that's important is in the Valadez case, my case that set case law in the published decision that came out December 29th, 2021, it was upholding the 2003 Act 130 passed by the Wisconsin legislature. And in that legislation we currently have in Wisconsin, it does identify how to keep families safe in domestic abuse situations in Wisconsin. Unfortunately, since that bill passed in 2003, we have not seen it being effective in Wisconsin courts. And of course, in my case, it has shown that the state, at the county level, the state legislation is not being followed and not having an impact and not protecting survivors the way the legislators intended as they wrote and passed that legislation. And in particular, the published decision in Valadez, it is upholding that when there is a pattern of domestic abuse identified in a case, which unfortunately was the situation in the Valadez case, there is a presumption in Wisconsin against the individual who's engaged in a pattern of domestic abuse to have sole custody. And custody is presumed to be granted to the safe parent in custody proceedings. Also, the legislation we currently have states that when there is a pattern of domestic abuse identified, that placement decisions must be with the children and the victim's safety as the paramount consideration. We also have in Wisconsin in that act requirements for different personnel in family courts to be investigating domestic abuse. So we added legislation for family court services and custody evaluators being required to investigate domestic abuse in each case. And we have for guardian ad litems a requirement for them to investigate domestic abuse. And unfortunately, my case has shown that that is not happening, and we don't really have an effective system of both the training and the oversight and the enforcement of the legislation we have. And that's part of while we're looking to pass the supplemental legislation in Julie's bill, to be able to expand on the intent in the legislation we have now so that we can actually see it being implemented to protect victims of domestic abuse as its intention is. We also had End Abuse Wisconsin come out in 2018 with a study that they did providing research on how this legislation is impacting Wisconsin families, and we saw that the legislation has not taken its intended effect in family courts. And so myself and many other advocates and survivors are working with organizations here in Wisconsin to continue to advocate for change. And that is part of this first purpose, and a little bit about why it's important to both uphold the legislation that we currently have, but really come around that legislation with more support so that it can be effective in really keeping children the priority and the safety the priority in family courts. And unfortunately, that did not happen for myself and my children. And in fact, to this very day, despite having an appellate order for that legislation to be and the laws to be followed, we still cannot get a legal order that is a requirement for our safety to be paramount to this very day. And the second purpose that the federal legislation identifies, it states, strengthen the ability of courts to A, recognize and adjudicate domestic violence and child abuse allegations based on valid and admissible evidence, and B, to enter orders that protect and minimize the risk of harm to children. And of course, this is extremely important here in Wisconsin. I will say that after the case law came out in my case, and my case was public and published nationally, I have gotten messages from women all over, including here in Wisconsin, about daily, if not for sure weekly, saying that essentially, me too. When I read your case and when I read about your story, it read just like what happened to me in court, and it read just like what happened to my sister or my daughter. And this is happening to many families across Wisconsin, and it's important that we come together as survivor advocates and as concerned citizens, and in the public interest, that we really work together on being able to strengthen our court's ability to actually have our judiciary and our court personnel enter orders that comply with the current legislation we have and increase the legislation so that we provide the supports for them to be able to enter appropriate orders, and orders that are sometimes in domestic violence cases, and more often than not, truly a matter of whether it's life and death or significant health outcomes when it comes to children's ACE scores and their health and well-being. We see increased risk of suicidal ideation and self-harm. Unfortunately, it's something that due to these unlawful orders in my case has been something that we've seen happen, unfortunately, with my children, and there's a number of others that have been impacted specifically by the same guardian ad litems that make these recommendations for unlawful orders and the judges that then enter unlawful orders. And we see very similar outcomes for these children. They are trying to run away when placed with the non-primary caretaker, and when they're not placed with the safe protective parent and they're placed with the abusive parent, they are running away, and they are increased risk of self-harm and suicidal ideation. And so it's extremely important that we look at how do we strengthen the ability of our courts to serve the public interest and to protect our children who are our future. After my case law came out, there is an article that was published in the Wisconsin Bar Journal in the family law section where it discussed the importance and the lesson of my case to the courts that domestic violence and domestic abuse affect children. And it's important that we look at the importance of protecting children, and that's what this second purpose is about. The third purpose that's identified in the federal legislation that we are seeking to pass here in Wisconsin in Julie's bill states that it is to ensure that professional personnel involved in cases containing domestic violence or child abuse allegations receive trauma-informed and culturally appropriate training on the dynamics, signs, and impact of domestic violence and child abuse, including child sexual abuse. And it is important that we add this additional legislation here in Wisconsin to be able to build on what was passed in 2003 in Act 130 and be able to bring more specific language around how do we help the courts, as the second purpose identified, in being effective at protecting children and entering effective orders for their protection. And that really is identifying specifically the kind of training that is needed in order to accomplish this. And we have seen a number of survivor advocates and our local organizations advocating for increased training. In 2021, we saw a study come out from the Wisconsin University and the state court system and End Abuse Wisconsin and others that were involved in really looking at what is the state of guardian ad litems in Wisconsin, and they came out with some recommendations for some changes for guardian ad litems. And we also had advocates that petitioned to the Wisconsin Supreme Court to add language in the Supreme Court rules for guardian ad litems that requires domestic violence training. So while we had legislation passed in 2003, it wasn't until 2021 that we had any requirement for guardian ad litems to have any training in how to investigate domestic abuse. And we still need to see more language around what the training requirements need to be for custody evaluators and the judges themselves in being able to effectively investigate, understand, and enter effective orders for the protection of victims in our courts here in Wisconsin. We are blessed here in Wisconsin that we have a number of active organizations and individuals that have been advocating for training. We had individuals such as Dr. Hanusa and Cyrus Baruzzi, and we have trainers in the Wisconsin court system such as Amber Peterson and Morgan Young, and End Abuse as an organization, and many others, including the Governor's Council on Domestic Abuse, that came together and actually published in the state court system a guidebook on domestic abuse for the state courts. And the Valadez case acknowledged that guidebook in, I believe, the first time in case law here in Wisconsin, and it is working to assist the courts in being able to uphold the legislation and the intent of protecting victims. And we have identified with experts what it looks like to do these investigations, how to understand the dynamics and the impacts of domestic violence, and we really need to see continued work on enforcing court personnel to be effectively incorporating this training that they have available to them now, and we want to expand that training. And those are some of the things that we can do with the purposes behind this legislation in passing it in Wisconsin. Another thing that we have been looking to do is go to the Supreme Court in further petitions for Supreme Court rules to strengthen the protections for survivors of domestic abuse in court. And we also have the Valadez case currently before the Supreme Court in a writ, asking them to add language and really upholding so that we can have the current legislation have additional case law so the courts can be following and supporting victims and children in their safety and requiring that safety be paramount. You can get involved in the letter writing campaign by going to tinyurl.com/WI Supreme Court letter and print that letter and sign, edit it if you'd like, and mail it into the Wisconsin Supreme Court. And another way that we are looking to have effective orders entered and some of this accountability is the current recall campaign out of the Waukesha County Courthouse. There have been 2 national articles published, one on my case and one on Jennifer Mostyn's case out of the Waukesha Courthouse and the failings of the family court in the Waukesha Courthouse. And Judge Abrahamian was reversed in the published decision in my case, and then subsequently for his retaliation directed at me was reversed for additional times and removed from the case. And we really need to see accountability if we want courts to be effective and we want to have some enforcement behind following the law for the judiciary and really upholding it as their oath requires, then we need accountability. And for Judge Ramirez to take the case and have the appellate order and defy that order and defy the legislation really needs to have accountability. So you can go to wisconsinwomenforchange.org and click on the recall campaign and learn about how you can get involved. You can print a petition and sign your name, collect 9 more signatures from Waukesha County residents, and turn that in to us for the campaign. And that is the intent behind Julie's bill, is looking at having this federal legislation keeping children safe from family violence, to strengthen what we currently have here in Wisconsin and to expand on it so that we really can see effective protection for victims here in Wisconsin.